Secondhand testimony is and never will be better than the witness's own testimony in his or her own voice for the record. For lawyers and parents, and perhaps even commissioners and judges who hate child custody determinations, temporary or otherwise, based upon proffer, I share this with you from the 1997 Utah Court of Appeals case of Montano v. 3rd District Court for the County of Salt Lake, Volume 934, Pacific 2nd Reporter, page 1156, pinpoint citation at pages 1157 and 1158. This court has previously expressed concern about determining custody based upon proffers given the seriousness and magnitude of child custody decisions. In Fulmer v. Fulmer, this court reviewed a permanent custody award entered based upon a proffer of witness testimony and the stipulated receipt of 2 child custody reports. In a footnote, we observed, although the parties stipulated that the testimony could be presented by proffer, and appellant does not argue that she was entitled to an evidentiary hearing, we note that an evidentiary hearing with all witnesses testifying would have been preferable. In a child custody case, we are convinced that witness demeanor and credibility are critical in ascertaining whether there has been a change of circumstances and what is in the best interest of the child. Any award of physical custody based solely upon what an attorney states a witness would have said and documentary evidence not subject to cross-examination is tenuous at best and subject to close scrutiny on appeal. Such deficiencies undermine the vitality of the trial court's determination. See also Hamby v. Jacobson, 769 Pacific 2nd Reporter, page 273, pinpoint cite at page 278. A 1989 opinion. Quote, in cases involving the best interest of a child and competing claims by parents of the child, demeanor and credibility of witnesses is particularly critical, and use of proffers should be discouraged. Close quote. Continuing the quotations from the Montano v. 3rd District Court case, quote, we reiterate that the use of proffers as a basis for child custody determinations, whether permanent or temporary, is discouraged. That is the end of the quoted material. The presumption that secondhand testimony from a child through someone other than the witness himself or herself is generally better than hearing from the witness is rationally and factually bankrupt. The idea that a judge, a former lawyer I should mention, charged with adjudicating a child custody dispute shouldn't interview a child who is the subject of a custody dispute, but should instead appoint a lawyer, remember, which the judge also was before becoming a judge, to do it instead, and in secret, is rationally and factually bankrupt as well. In light of the sentiments expressed in the Montano decision, I ask you, why appoint PGALs, that's private guardians ad litem, or custody evaluators who A, refuse to record their interviews of the children, if they take place at all, and of the collateral sources for the record, and B, refuse to allow children to testify and or refuse to interview children on and for the record in child custody dispute cases, and C, continue to insist that secondhand testimony is better than the witness's own testimony in his or her own voice? How is that defensible?